Morning.
Good morning, all.
Professor Smart, good morning.
Good morning.
You can hear me okay, audible okay?
So far, so good.
Okay. Yesterday, we had a brief discussion about your working papers. And I was concerned, and I'll express it as my concern, that the numbers at compendium page 18 of negative $4.5 billion for NCRRs did not coincide with the data in the work papers. And do you recall that discussion we had?
Yes.
Perhaps what I did last night might help with clarifying this up. We're sharing on the screen now data from your May 14th, 2023 work papers that we found. And I wonder if, first of all, you could let us know if there's any work papers after May 14th, 2023.
Well, I've not been involved in the process of making the work papers available to you. And so I don't know when you received which version of my work papers. As you are aware, I don't have access to the computer files in question while I'm sitting here in the stand.
Yeah.
So it may be difficult for me to reconcile any questions that you have about differences between the updated version of my working papers that are on my own computer and the ones that are on yours that you received on any particular day.
I think perhaps we can work with a hypothetical. Let's use a hypothetical that what is displayed on the computer screen right now is in fact the May 14th, 2023 work papers. Can we just assume that for a moment?
I'm willing to assume that it's what you received on May
Yes.
14th.
I'm not suggesting it's what you gave your Ontario's lawyers. I am suggesting it's hypothetical is what we received. If it is what we received, would you agree with me that the entry at line 340 of minus 4,805,575,449 is incorrect?
Yes, I agree.
And so if this number is wrong in the work papers that we received, and if the court has the same work papers, would it be fair to tell the judge to be careful about using the work papers that the court has?
I think it's a question you should take up with Ontario's lawyers and the court rather than me personally. I can answer questions to the best of my recollection about the version of the work papers that's on my computer now, but my ability to do so is limited because I don't have access to that computer now. I do know, however, that that number does correspond to what I think of as the May 10th version of my work papers. As you pointed out, the version of my work papers, it was the final version. The corresponding number would be, rounding in a scientific way, we would say minus 4.6 rather than minus 4.5 billion, but we're talking about the same alternative number. And the difference between those two numbers, minus 4.8 and minus 4.6, represents the impact of the late change in my calculations that I explained on the first day of my testimony related to the RST railway trackage share estimates. And that would be the only difference between those two versions of the work papers.
All right. And just to sort of square this circle, over at tab 4, page 18 of the compendium, when you refer to negative 4.6 billion, it's really the number in the updated table 1 of minus $4,581,149.40, sorry, $149,000.42.
Yes.
I wonder then if we could go to the first page of tab 4 of the compendium for a moment, because I wanted to ask you some questions about your original results. Now, I do appreciate that your summary or your final results have changed in ways. And one of the ways is that the unadjusted NCRRs went from, I'm rounding, minus 7.8 billion to minus 4.5 billion. And the risk adjusted NCRRs in your original report were negative $19 million. You see that on the screen in front of you?
Yes.
Your original report without the adjustments. I wanted to ask you a question about expectations and understandings. Yesterday and in your direct testimony, you talked about people in 1850 knowing what eventually happened. That you can use that as a proxy for what they understood might happen. Do you agree?
No, I don't agree with the statement you just made as characterizing what I said yesterday.
Okay, so would you agree with me, sir, that the reasonable expectation hypothesis can tell us nothing about what people understood in 1850 when in entering into this treaty?
I'm going to ask you to rephrase the question because it involved a question with a negative. I became confused. I'm sorry.
I'm going to try it this way. In 1850, what do you say the Anishinaabe and the Crown understood was going to be the result in 2019 in terms of the amount of unadjusted NCRRs?
Yes, I understand. Thank you. We cannot know what people believed in 1850. Those are subjective, what economists call subjective expectations of the future. To model the expectations and understandings, and therefore model the values people would assign to NCRs, we must make a guess about what their subjective expectations were. I adopted the standard technique in economics of assuming that people's subjective expectations of the future coincided exactly with what actually did happen in the future. However, economists who adopt that assumption recognize that it is a simplifying assumption, which in practice may be incorrect.
Thank you.
Can I add one more sentence?
You can add as many sentences as you want to help the court.
The question is, what alternative assumption could I make about subjective expectations that would be more accurate than the assumption I just described? I could assume that people were persistently too optimistic about the future, in which case I would conclude that the values were higher than I did estimate them to be. Or I could conclude they were persistently more pessimistic, in which case I would conclude the values were lower than in my estimates. In either case, there would be no basis in the economic data for that alternative assumption that people were either too pessimistic or too optimistic. So in my view, in the view of economists who adopt this assumption, the assumption that I've made is a central and reasonable approach to trying to estimate other people's estimates of future outcomes.
All right, so let's use another hypothetical for a moment. And in this hypothetical, you're actually correct that both the Anishinaabe and the Crown believe that the unadjusted NCRRs would be minus $7.8 million in present day terms at bond rates. Can we assume that that's what they actually understood? Just a hypothetical.
Yes,
If that were the true assumption, if that were the case, do you think that the Anishinaabe would have had to have paid something to the Crown to take the territory off the Anishinaabe's hands? Would that have been reasonable?
I think there are two possibilities in that hypothetical case in which people had negative expectations of the future and, according to your hypothesis, did not risk adjust in the way that I've said that people would have done. So taking your assumptions, which I do not accept as hypothetical starting point, then I would conclude that the Crown would not be willing to pay anything to the Anishinaabe, the Anishinaabeg, in order to gain the benefit of the NCRs that would flow.
Thank you. Now, let's move to another hypothetical in a moment, but in the hypothetical I just proposed to you, would you agree with me that we know, as a matter of fact, that they did enter into a treaty?
Yes,
So using can I call it a smell test, or is that not fair to you? Am I being unfair?
you can use any words you choose.
All right. If I call it a smell test, does the smell test suggest to you that the negative number probably isn't minus $7.8 billion?
Well, now I have to ask you to explain your words. What does smell test mean? And what does the number mean?
Okay.
Quoting your question.
I'll try and rephrase it. The reality is that we do know that a treaty was entered into. You agree with that?
Yes,
And you've just told us that the Crown would be unwilling to pay anything under my hypothetical for the resources, for access to the resources. You just testified to that effect.
are you asking me if I agree with the?
I'm asking you just, isn't that correct?
That's not what I said.
Okay, maybe we will have to read back what you said. I would conclude that the Crown would not be willing to pay anything to the Anishinaabe, in order to gain the benefit of the NCRRs.
Yes,
And you thought that I unfairly summarized that statement in my last question?
yes.
How did I unfairly summarize it? Because I want to make sure that if there's key words, important words for the judge to understand, I want to try and make sure we're using the same words. So I'm not trying to be critical. I just want to understand what was wrong with my phrasing that the Crown would be unwilling to pay anything under my hypothetical for the resources, for access to the resources. You say that's wrong.
Yes, I specified that the values that I estimate are willingness to pay for the NCRs They're not a willingness to pay for the treaty or for the, to quote you, access to the resources.
All right. So,
Sorry, can you say that again?
Yes, I'm making a distinction between the value, expected value of the future NCRs, net Crown resource revenues, and the willingness to pay for anything else that the Crown might feel it gained access to through the treaty. In my view, the augmentation promise as interpreted by the Court of Appeal means that the value of augmentation is to be based on NCRs.
all right, and let's stick with the hypothetical for a moment. And as an economist, are you able to help us or help the court understand what other things the Crown would be willing to pay for to achieve a treaty?
That was not part of my assignment.
Appreciate that. Do you have, is there any economic principles you can assist the court with on that?
I have made no study of the history of the treaty making process in Canada, other than the specific economic aspects of the Robinson treaties. Of course, there are economic principles that help to determine a willingness to pay of any party to acquire any asset or any right or property of any kind. And we could discuss them. I don't think that those generalities would be particularly helpful to you, Mr. Schachter, or to this court. But if you ask specific questions, I would attempt to do that, of course.
Can I just see if I understand
Mhm.
what's going on? In your answer before this one, you said, I make a distinction between value of future NCRRs and the willing to pay for anything else that the Crown might feel they've gained access to through the treaty. Then the question was, what are these other things? You say, don't ask me. Well, there must be something in your mind when you say NCRRs or other things. What could those other things be? Possibly as an economist, you think it's, I don't know, trite, but I don't know what it is.
I just don't, Your Honor, I don't want to pretend to be an expert on things on which I'm not qualified as an expert, but I'm, of course, I'm happy to offer the court my insights into the economics of what we call willingness to pay in general. And of course, I have some understanding of the history of Crown Indigenous relations in Canada and of the treaty making process, although I do not present myself as an expert on it. In saying the treaty involved the acquisition of other things other than a stream of future NCRs, I believe I'm stating something that we all agree to be true. And I can expand on it if you wish.
These are your words and your idea. I'm not asking you to give an opinion on something outside your expertise. I have no idea what other things mean. That's all I'm saying.
Well,
What other things? Are there characteristics of other things? Is there some realm of other things? Is it experience? Is it emotional? Is it political sovereignty? What is in your, I don't know what's in your mind.
well,
Can you
I
say
will
that?
answer that, Your Honor, because I think you're asking me to. But I want to start by perhaps adopting Mr. Schachter's sort of framing of the questions as a hypothetical, because I think perhaps that's the way a court operates, although it's outside of my direct experience. So if you will, what I'm saying is, Mr. Schachter asked me, well, then if it's negative, then there would not have been a treaty. And my response was, no, I didn't say that. I said that there would be no willingness to pay for the NCRs. It might have been willingness to pay and therefore acquire this territory through treaty for other reasons. So everything is couched in a hypothetical in which the Crown did have other objectives. And then what I am saying is those other objectives may have led to the signing of a treaty, But the augmentation clause, as I understand it, and as I understand the Court of Appeals decision on what our assignment here is at stage 3, relates not to those other hypothetical objectives the Crown may have had in 1850 in concluding the treaty. The augmentation clause and the value of it I was asked to estimate relate only to the NCRs. And so, to be absolutely explicit, we can imagine a contract that says we're engaging this contract because of a broad, by we, I mean any party to any contract. We're engaging in this contract because it satisfies a broad set of objectives of all the parties to the contract. And one clause of the contract relates only to a subset of those issues and objectives. So that's my starting point. There's a hypothetical question that you posed to me. What else could the Crown be thinking about?
Sir, I don't think that's hypothetical. I'm dealing with your answer.
Yes. Well, I will answer because I believe you're asking me to, but I don't think my answer is relevant to the question of how I estimated the value of NCRs, which was my assignment. But my understanding, and here's my answer, my understanding is that the Crown had other objectives including nation building. They sought to acquire territory, not simply to acquire future NCRs, but to acquire the territorial advantages. And in particular, I can imagine, without any expertise, that the one objective of the Crown in acquiring the land on the north shore of the northern Great Lakes was to prevent the American state from acquiring those lands. That's an example, and by no means the only example that one might think of, but it's the first one that occurs to me.
Are there any others that you want to help the court with?
Again, I emphasize I'm beyond my expertise. I'm beyond my expertise. Evidently, the Crown represented economic interests that were already in operation within the territory. The Crown sought to regularize those economic relations those parties were engaged in. The Crown had sold licenses. We understand this from the stage 1 decision. The Crown had sold mining licenses within the territory without a treaty in place. That's a fact. Of course, it's absolutely clear from Robinson's instructions that that concerned the Crown. More broadly, we know that the Hudson Bay Company was operating within the territories and so on. We can imagine many other factors that led the Crown to sign a treaty that do not relate to NCRs and therefore, in our opinion, do not relate to the augmentation clause.
All right.
Okay.
Okay, how much time do you need? Okay. Professor Smart, might one of the other reasons being
I think
access to customs and excise revenues?
Mr. Lipton is on his feet. Yes, sir.
I'm concerned that this line of questioning is asking for lay opinion evidence outside of Professor Smart's expertise.
I don't know what Mr. Schachter says. I don't see it that way. I see it as pursuing this witness's answers. Go ahead.
As an economist, you know something about, and public finance, you know something about public finance, right?
Yes,
So you
Thank
know
you.
about, you've heard of customs,
yes,
you've heard of excise taxes?
vaguely. Excuse me, that's a jocular answer. I apologize. I am familiar with customs and excise.
All right, so might it be that one of the reasons why the territory would be acquired in my hypothetical under a treaty is by access to customs and for the purpose of accessing customs and excise duties?
Anything is hypothetically possible. We can imagine many objectives in the minds of the many actors that formed Crown policy up to 1850. In my opinion, that one is less plausible than some others.
What about access to for the purpose, you did include political purposes, right?
I said nation building.
Yes. And is it fair then to say that knowing that in my hypothetical, knowing that the Crown, it was going to suffer a $7.8 billion loss over the years, the value of those other benefits would at least equal the $7.8 billion loss they were prepared to accept. Would you agree with that?
I don't agree, and I would like to explain. I do not think the Crown valued future NCRs at minus 7.8 billion. In my opinion, the way you frame that question suggests to me that you don't think so either. And therefore, I conclude you and I are of like mind in this regard. The Crown, whatever expectation it formed, whether it was higher than minus 7.8 billion or lower than minus 7.8 billion, both of which I've clearly stated, I think are possible, would not have assigned that value because they would not have thought that the expectation, if they held it, of large losses beginning in the 1960s, more than 100 years later, they would not have held that expectation in sufficiently high confidence to put much weight on it in forming their valuation. Instead, they would have discounted any expectations they had, whether optimistic or pessimistic, about NCRs 100 years later or more, and they would have assigned instead a value in the neighborhood of, much closer to, our risk-adjusted present value of NCRs, which, as you know, is not minus 7.8 billion. It's not minus 4.6 billion, which is our estimate of actual NCRs. Instead, our estimate of risk-adjusted NCRs, that is our estimate of the valuation that was likely to be held, was 169 million, a positive number.
I thank you for that answer. I am dealing then, sir, with page 17 of the compendium where the risk-adjusted NCRRs on a minus $7.8 billion amount is minus $19,427,579. That was in your original report. It was a negative amount, not a positive 168, but a negative minus 19 million. You see that?
Yes.
Your
Could you remind me, please? Page 17 of the compendium.
page 17 of the
What is
compendium is
what is the
original
source?
table 1 that before Mr. Hutchings provided some information under which Bodway and Smart ended up with a minus 4.5 billion was the amount that was in their original report that they were of the opinion was appropriate and correct information.
And it's pre-reply of Hutchings? Is that what you're saying? Or,
It's pre-reply of Hutchings, that's right.
and
and-
Mr. Lipton is on his feet?
Oh, I'd just like to add to my friend's comment, because I think he didn't provide all the information that's required for the court to understand this. He referred to the numbers being adjusted solely in response to Mr. Hutchings' opinion. Professor Smart has already testified that he did some of his own work and adjusted the numbers of his own motion. So I just wanted to remind the court that that was also.
Well, we'll leave that for the witness.
Sure.
Your question, Mr. Schachter, referred to page 17, and I am just getting it. So
Yeah.
is this table in the original report of?
Yes,
Bodway and
it's
Smart?
it's in the original report and it is still in the report before the court. It's in the present value 60 exhibit 61. This is part of exhibit 61. It hasn't changed.
I don't want to speak out of place, but I wonder if I could,
So
Oh,
that was a
just-
question to Mr. Schachter. If there's a correction, I wouldn't mind just getting this down.
Yeah.
I do think I could provide more information on the point that Mr. Schachter just made.
Okay, if you just hold it for 1 second, I'll get to you. Okay, go ahead.
I only wish to say that what's displayed on page 17 of the compendium and on the screen right now is not a page from the document that we submitted to the court in June of 2022. You will see that it has been redacted. That was done by Counsel for Ontario. And
So the difference between what you submitted and this page are the redactions?
I cannot, I believe that to be the case, but I cannot guarantee it. I do not have access here to the version of the document
okay.
that we submitted. And I,
Do you
all
have
of
any
that
reason,
took place outside of my hands. And so I don't know.
do you have any reason to believe, were you advised that Ontario Council changed any of your numbers when they did this redaction to, as I understand it, redact references to the RHT?
Well, I was asked to produce different versions at different times, and I'm not entirely sure that the RST numbers here correspond to the ones that I
Right.
gave Counsel for Ontario in June of 2022.
My question to you is, do you have any reason to believe that Ontario Council changed your numbers?
No, I do not.
Were you ever advised that they changed your numbers?
No, they did not.
All right.
Do you have your report? Your present value report? I'm going to pursue this because I think it's important that the court doesn't have a wrong report in front of it if there was a mistake made.
There is no suggestion of a mistake being made. Your statement that this was my report from June is not correct.
Sorry, in particular, you're referencing what you see it to be the redactions.
The fact that it's redacted tells me it is not this report that I submitted through Counsel for Ontario in June. And that is all I know. I wish to correct Mr. Schachter in that regard.
Do you know what was redacted?
Of course, I know it was evident from what was just displayed that the redactions related to RHT.
Did you author the redactions or did someone else do the redactions?
Sorry, could you, I could not hear.
Do you take ownership of the redactions that were made?
No,
You haven't reviewed the redactions before they were made?
yes. I have. Professor Baudouin and I have reviewed the redactions.
Are the redactions correct?
We do believe that they are correct, and we take ownership of the version of our report that was submitted to the court recently. But your statement that that document was submitted in June 2022 is not correct.
Yeah, can you take a look at your June 22 report?
I don't have it.
We've got it.
Well, it's in the court records. Perhaps we can.
We've
pull
got it.
Oh, sorry, before we put it on the screen, can we take it off the screen, please? So, sorry, so the concern that we have with putting the June report on the screen is that it contains numbers with respect to the RHT and the Restore action.
Yes.
There was a specific reason why those numbers were redacted. The Crown and the Restore plaintiffs are currently in negotiation.
Yes.
And as a result of those negotiations, we made substantial efforts to make sure that those numbers were not put before the court. There are other ways to deal with this, which do not require those numbers to be on the screen.
Let me try and deal with it
Okay.
that way. I'm trying to establish that the report that the court has the exact same numbers as appear on page 17 of the compendium. Would you agree with that, or do you don't know?
I do not have access to the June report. You have me at a disadvantage, sir.
Mr.
In-
Lipton, are you offering something?
I'm offering my friend in. Um, if it would be helpful to my friend, there is an electronic copy of the June report with the table one. I'm not sure if you want it.
No,
Okay.
no, I don't, thank you, counsel. I'm not. I'm trying to find out and make sure that the report that the court has is consistent with what is in the compendium at tab 4. And I'm going to suggest, suggest to you this way. You had a report in June. Following that report in June of 2022, you did more work and your numbers changed. Is that true?
Yes,
But as it relates to RST, none of the numbers that changed found their way into an amended report. They only found their way to the court through tables you provided after the fact. Is that right? Or do you not know?
it is difficult for me to parse questions that are posed in the negative. I would ask you to repeat the question if you can, please, in a different way.
On June of 2022, you prepared a report.
Yes,
That report contained information about RHT and RST. Is that correct?
yes,
After June 2022, your data in respect of RST changed. Is that correct?
yes,
Those changes are not contained in Exhibit 61 before the court. Do you agree with that?
yes, I believe so.
Thank you. Now, returning to compendium page 17, which is page 12 of Exhibit 61, and the risk-adjusted NCRRs identified therein are shown as minus $19,427,579.
I would ask that it be displayed on the screen.
Sure. You can also look on the compendium that you should have in front of you as well.
Thank you. I will do so if you wish, but as I said yesterday, it's more effective for me to look at you.
All right. And I'm going to put it to you that if that were if the negative $19 million was in the minds of the Crown, I submit to you, they would not have acquired the rights to the resources. Do you agree?
No,
You were asked after Mr. Hutchings took the stand to revisit your numbers at some point. Is that correct?
no, I don't recall it that way, and perhaps I could expand. We prepared a report that you neglected to mention earlier, a reply report that was submitted in December. In it, we responded to some issues raised by Mr. Hutchings in his reply report of October. And that engendered certain changes to our calculations, which were discussed in our December report. Furthermore, in reviewing Mr. Hutchings' testimony and preparing for my own, I realized that two more changes should be made in my calculations. And those were not reflected in any report prior to that, but were fully described in my testimony and are fully reflected in all the tables of numbers that were included in my demonstratives.
And how long did it take you to make those changes?
It took as long as it took. I think you're asking me. It's not clear what you're asking me whether, can you explain what you mean by how long?
You identified a number of changes you wish to make in your report. Is that correct?
Yes.
When did you identify those changes?
Well, it depended. The one that I keep coming back to was quite consequential for the estimate of unadjusted present value and even of the risk adjusted present value. That related to the share of railway trackage in RST, which I adjusted downward and therefore adjusted upwards the value of the NCRs and the value of the annuities that hypothetically should have been paid. That did not become apparent to me, and I apologize once again for this, until I reviewed the first draft of my own demonstratives. That happened less than 2 weeks ago. Once I realized that I wished to change my estimate, within 3 days, I had produced the new version of all my calculations. I mentioned in answer to your previous question that there was one other change that occurred only after I became aware of something in Mr. Hutchings' testimony that I wish to respond to. And that happened at some point between his January 2023 testimony and the preparation of my own demonstratives for testifying here. I cannot recall precisely when, but I think it's very likely that occurred sometime in April in the first instance. Again, the specific calculations involved would have taken only a few days to perform. And I cannot really be more precise than that. In review then, two changes occurred later than the final report that Bodway and Smart submitted, that we submitted to the court.
Just
And
so I
that's the-
understand, when you say two changes occurred later, two changes occurred, you made two changes after the final Bodway and Smart report.
After the SIR report, I believe is the correct title, submitted in December, two other changes occurred after that.
Thank you.
It's December 2022.
Yes.
And can I also ask one other question arising from this? You made one change with respect to the railroad trackage in the RST, and then you said there is also another change. Could you identify what that is related to, please?
Yes, it relates to fish and wildlife expense in the post-1970 period.
Thank
Mr.
you.
Hutchings raised an issue and
It's okay. I just needed to be reminded of what it was about.
yes,
Did you receive any instructions at all from council about revisiting your numbers as a result of Mr. Hutchings' testimony?
Mr. Lipton's on his feet. Yes,
I
sir.
believe my friend is asking a question which touches on litigation privilege matters.
I'll try and rephrase the question. When did you find out that there were changes to be made to your numbers based on geographic changes to the area under consideration?
so I believe you're asking now about a separate issue we have not discussed so far today. And that is the so-called agreed area, the agreement between parties about the geographic area of the RST. And I know that it took those, I was alerted to those discussions being ongoing in 2022. I do not recall when I was told about the agreement, nor when I do recall that I did not receive a map describing the agreement until sometime in 2023, and that those calculations, which also affected the final numbers, didn't take place. I didn't do them until April 2023.
Late April 2023?
I do not recall. However, I do recall that I concluded it was best to do that only at the same time as I was verifying and validating all my numbers for the purpose of concluding my testimony. My reason for that is it is very complicated to do the calculations that we are doing. I'm sorry if that doesn't make sense to anyone, but I think it's true.
I thought it was an understatement.
Thank you, Your Honor. It's also true, and I don't mean to say that this case is anything other than the most important thing I'm working on, but it's also true that until early April of 2023, I was teaching. And so much of my work was delayed until after my teaching commitments were done. Again, I do not say that to suggest that anything takes priority over this case, but in thinking about the best way to get the work done and keep my focus on this case, I thought it was best to do the work after my teaching commitments had been completed for the year.
Do you know when your teaching commitments ended?
First week of April, 2023.
I'd like to move to another topic called resource rents. And if you'll look at compendium tab 5, you'll see a number of slides that are already in evidence. And the first slide is part of trial demonstratives of Professor Joseph E. Stiglitz. And we're going to put that up on the computer for you. And I don't know if you watched his testimony of how he defined and described rents, did you?
I watched a couple of hours of Professor Stiglitz's testimony. I don't recall if it included this slide.
All right. Would you agree with me that the description of resource rents identified on page 19 of the compendium, which is trial demonstrative number 21 of Joseph Stiglitz, is a fair and accurate explanation of rents?
Well, Mr. Schechter, there's a great deal to review on this slide. If you're willing, I will read some of the words out loud and comment on them. Would that work for you?
I want to know if you disagree with anything that he says on slide 19. And if there is something you disagree with, please feel free to tell the court.
I will need some time to review it, but I'm willing to do that here and now if you're willing to wait.
Yeah.
Okay, I'm ready. If you could pose a specific question, I'll do my best to answer. I know you did, but I would ask you to do it again.
Is there anything inaccurate about the depiction of rents and how and who captures the rents in slide 21 from Stiglitz found at page 19 of the compendium?
There are statements here which are contentious that would need to be probed and qualified in certain ways before I or many other economists would accept them.
Do you agree, sir, that the Crown captures rents directly through direct fees as in royalties?
Yes, with the qualification that the word fee here is not used. I would not use the word fee and the word royalty as synonyms myself.
Do you agree that investors may capture rent through higher returns than necessary to compensate them?
We would, in this case, want to understand what Professor Stiglitz meant by returns necessary to compensate them.
You don't know.
I don't know. I can offer some conjectures here. And indeed, I think the distinction that's being made here is not consequential. So when we speak about investors, we mean the people who are possessing some ownership claims to investment companies and investment projects involved in resource extraction. Do you agree with me, sir?
Yeah, maybe I can be some help. You'll notice it's green and it's supposed to relate to capital. You'll see that there's the word capital in the tower. And there's rent, capital, suppliers, and labor, and each one has a different color. And what Professor Stiglitz, as I understand it, was trying to identify is that investors, those who invest capital, may capture rents through higher returns than necessary to compensate them for engaging in the business. So with that definition, do you agree with that?
I agree that in some situations, investors, owners of capital, receive what economists call supranormal returns, or I believe equivalently, we would say excess profits in
Okay.
some circumstances.
Thank you. Now, the next one. Do you agree that suppliers may capture rents through higher prices for their goods and services?
In general, I don't think that would be part of my core model of the distribution of rents across different parties. Suppliers would not capture rents unless they had specific market power that allowed them also to earn supernormal profits. And if they did earn supernormal profits, I would not be inclined to identify, in that case, those supernormal profits as resource rents. And I would like to offer just one sentence of explanation. For economists, a normal profit is the return that capital providers must have in a competitive equilibrium in order to make them willing to supply capital. That concept, the normal return, is very similar to the concept of the time value of money that I discussed during my testimony. There are many cases in which economists believe, in practice, profits of companies, and therefore the income of the capitalists owning those companies, may exceed that normal return to their investment. And the most important example, I think, in general, in economic theory and practice, is what we call monopoly profits. So some investors may have a position of market power, which would allow them to charge higher than the competitive prices for the things that they sell, in which case their profits would include supernormal profits, not merely the normal return to capital. There may be some suppliers, therefore, to resource projects that have such market power and which would earn supernormal profits, but I would not attribute that to the fact that their customers in that example are themselves engaged in resource projects. And therefore, I would not attribute those supernormal profits to the resource rents.
All right, so we've identified one area of disagreement.
Good.
Professor Stiglitz was also of the view that labor may capture rents through higher wages and salary. Do you agree with that?
In some cases, Yes, and I will give one quick example, quicker than the last one. We believe, economists believe, that unionization has an impact on market wages, that the presence of a labor union can give rise to higher wages than would occur in the absence of a labor union. Indeed, this may be an example of the kind of market power I talked about before. Labor unions negotiating with resource companies over long-term employment contracts would have some awareness of what the resource rents the company could earn would be if unionization and the regulations that exist to protect workers in those environments, such as the rights of collective bargaining guaranteed by law, if that limit the ability of employers to look elsewhere to hire workers, then it's possible that union contracts would result in higher wages, partly attributable to resource rents.
So you agree with Professor Stiglitz on this one?
In some circumstances, and the circumstances that I described related to unionization.
Let's go over to page 20 of the compendium. This is a Stiglitz slide 22, where he opined that the Crown also captures rents indirectly through general taxes and other factors of production, recapturing some of the rents not initially captured. Do you agree with that statement?
I have not reviewed this slide. In this case, I'm certain I did not follow along online to listen to Professor Stiglitz's testimony around this slide. I don't feel there's enough information on this slide from me to be able to give an intelligent comment. And I don't recall discussion of this issue from the reports by Mr. Hutchings or Professor Stiglitz and Mr. Hutchings that would support what I'm seeing in that one sentence on this slide. I wonder if you would give me an opportunity to review the Stiglitz-Hutchings report before answering questions about this.
Sure.
So unfortunately, I don't have Professor Stiglitz's report here. It's clear in the footline that he believes that section Roman 5D1 of his March report would speak to this question.
We'll
If
try and
you
put it on
have
the
that-
screen for you. We're going to try and put it on the screen
Thank
for
you.
you. Unless your council has a copy of your, a hard copy that you can look at.
We do not, though I think in fairness to the witness, it would be better if he were provided with a hard copy so he could review the section.
Well, we'll just ask him once, we'll put it on the screen and ask the witness whether he needs a hard copy.
Well, I see it's 4 pages. I think I would prefer to have a chance to read those 4 pages before answering.
Let's put them up on the computer and maybe we could take a break. Maybe now would be a good time to take an early break. I don't know. And we can let you read it and at your leisure.
Okay. Good time to break, Mr. Lipton, you're on your feet.
Oh, I was just wondering, we could print a copy for him. I think we have a printer upstairs.
Great. We don't have a printer here.
Very good.
That
Thank
just
you,
might be
Mr.
easier
Lipton.
for everyone.
Okay. 20
Okay,
minutes.
will work.
All right. And the court is asking for 20 minutes for the
Yes,
break.
that'll be fine. Thank you so kindly.
All right. This will recess for 20 minutes. I was you may be seated.
Sorry, Your Honor. So we've located a paper copy and we've made a photocopy of it for Dr. Smart to review of the Stiglitz opening report dated January 24th, 2023, and this is section Roman BD1. Madam Clerk?
Well, why don't you let
Sure.
Mr. Schachter manage this?
So your counsel didn't hand this to you during the break?
No. Thank you for coming over.
Go ahead, sir, and take a look at it.
Oh, I've already reviewed my own electronic copy of it during the break, and I'm ready to answer any questions you have.
Okay,
Okay,
If I did something wrong, I'm sorry.
let's, my question was about compendium page 20 and the demonstrative that Professor Stiglitz used to try and summarize rents. And he postulated for the court that the Crown also captures rents indirectly through general taxes on other factors of production, recapturing some of the rents not initially captured. Do you agree that that's accurate?
I agree that the statement on the slide on your compendium 20 would follow from the statements Professor Stiglitz made on the slide on your compendium 19. In particular, he asserts on a prior page that some portion of resource rents appear in the incomes of other factors of production. If the incomes of other factors of production are taxed through general taxes, then it would follow from the statements on compendium page 19 that some of the income tax revenues could possibly be economically incident on that portion of the rents that appeared in those other factors. I did review section Roman 5D1 of the Stiglitz-Hutchings opening report, and I did not find statements to support the conclusion that other Canadian taxes were incident on resource rents. In that section, I saw no discussion, for example, of the most important tax in our or any Western country's tax system, which is the income tax. There was a reference there to the Israeli income tax system and its effect of taxing resource rents from natural gas, which I don't think is sufficiently relevant to discuss here. Any Canadian economist who wished to address the question of whether income taxes were incident on resource rents would, in my opinion, make some reference to the division of powers in the Constitution Act between Canada and the provinces, and in particular, Section 92, none of which was discussed in Section Roman 5D1 of the Stiglitz-Hutchings report. So I don't think that, in my opinion, the information on your compendium, page 20, supports in any particular way the idea that actual Canadian taxes, other than provincial resource taxes, have been incident on resource rents.
Is that a long way of saying you disagree with Professor Stiglitz?
Don't think that, I don't know. So I think that the statement on slide 20 follows from the statement on slide 19, your page 19. But I don't think that it's supported by evidence about the Canadian tax system.
So you would disagree with Professor Stiglitz's statement that the Crown also captures rent indirectly through general taxes on other factors of production, recapturing some of the rents not initially captured. You would disagree with that?
It's possible that that happens. A fully understanding of the extent to which it happens would require estimates of the extent to which resource rents appear in the incomes of other factors of production, which Professor Stiglitz's own report acknowledges that he has not provided. And it would require some understanding of the structure of the Canadian income tax, which was not discussed in that section of Professor Stiglitz's report.
would you agree with me, sir, that whatever resource rents exist, they exist independently of who eventually captures them? Would you agree with that?
I believe you've asked me, whatever the resource rents are, that's what they are, regardless of who captures them.
The question I asked, yes.
And as an accounting matter, I agree with that.
Not as an economist? You don't agree with that as an economist?
Well, I think that the structure of power relations, and in particular market power, affects who earns what in the economy and what prices are charged for different things. So that changing the ownership of the resource rents could, in some circumstances, give rise to a change in the ultimate level of investment, and so the level of resource rents that are actually produced.
But that wasn't the question. The question wasn't about the level or how much. It was a conceptual thing. Whatever they are, however they are, whether it's $1, $10, $100, $1 billion, whatever they are, those values exist independently of who captures them. Would you agree with that?
Yes, I think that's a statement about accounting. We would add up the resource rents wherever they appeared in the economy to arrive at a total. So yes, I agree with you.
But not just as an accounting function, as a professional economist, you would agree with that.
Yes.
Thank you. Can we turn to page 21? The compendium. This was an exhibit that was contained and put to Professor Mintz in his cross-examination, and it was entered as an exhibit. And you'll notice that it's not to scale. And it was just an attempt to try and conceptualize rents. And I wonder if this more, I'm going to call it simplistic because I was the author of it. So I just wonder if you would agree with me that parts of rents are captured as NCRRs. Do you agree with that principle?
Yes.
And the second row is a yellow row, and that's supposed to depict rents that are captured by the Crown and others. Might it's not to scale, so it might be closer to the red line or closer to the top of the green bar. But whatever that bar is, would you agree that the portion that the parentheses says there's a portion of the rents over and above NCRRs that are actually captured by the Crown that are not included in NCRRs is in this range? Is that a fair statement of what happens in the real world?
Well, first, I'm trying to understand what I see before me here and related to your words. I see that the yellow bar is labeled rents actually captured by the Crown and others.
Yes.
And I agree that not all rents that are actually generated are captured as NCRs. So I agree that there is a yellow bar in excess
Yes.
of the red bar.
Yes.
But then in your question, you seem to conceive of the yellow bar differently than what I read. So
Well, in parentheses, over and above the NCRRs, which are captured by the Crown, there are rents that are captured by the Crown over and above NCRRs. I think that's the point that the yellow bar is trying to show.
I will offer comment on that if I may. We know that not all rents are captured by the Crown. If so, we would conclude the effective tax rate on rents was 100%. And as I've said repeatedly, we don't think it is 100%. We don't think it's possible that it could be, although that's a separate question. So there is a yellow bar. Included in the yellow bar, in excess of the red bar, would be, as I understand how you define those bars. Also, not just the after-tax profits of the resource companies, but it could include other taxes accruing to the crown, other revenues accruing to the crown that were not labeled by the person who created this figure as NCRs. So that's possible.
And the third bar is green, as I see it with my eyes. And it's a world that we'll call it optimal management, that there could have been more rents than actually happened in the real world over the last 174 years if different choices were made. Would you agree that that's a theoretical possibility, that they could be higher than what the crown, higher than what the resource rents could be higher than what they were?
I mean, I guess in general, everything could be different than
Right.
what is. So yes,
And would you agree with me that Professor Stiglitz and Mr. Hutchings do not try and devalue or claim for the plaintiffs any part of the green bar that goes above the yellow dotted line? You understand that?
I think I do. I think the green bar is your own notion, Mr. Schechter, of something else that might be measured as rents, or that could in some alternative but for world be measured as rents. And that whatever you're capturing in the green bar, I'm not aware that it's in any way related to what the Stiglitz-Hutching reports were attempting to capture.
Yeah, okay, thank you for that. Let's move along then to your instruction, if we could. And can you go to paragraph 3 of Appendix H to your present value report? That's Exhibit 61, I believe.
I have the appendix. Could you repeat the page or paragraph?
Okay, so let's start with page 6 of your report, paragraph 3. You say the full instructions we received from Council for Ontario are appended at Appendix H.
We're at 61, exhibit 61.
We're looking at Exhibit 61, page 6, paragraph 3 of your report.
I'm not currently looking at that page. You asked me to turn to Appendix H originally. Would you like me now?
Yeah, yes, please turn to it.
Page 6.
And the page in, are you pointing to any particular page in Appendix 8, Mr. Schechter?
Appendix H, I haven't, I'm not at Appendix H yet.
Oh, okay.
I'm
sorry.
at page 6 of Exhibit 61, paragraph 3, and the statement that the full instructions we received from Council for Ontario are appended at Appendix H.
And you have,
I just want him to confirm if that's true.
I can confirm that that's what paragraph 3 says.
Yeah, it's not the question I asked.
Could
Is
you
it
repeat it?
true? I
Could
didn't
you-
ask you what it said. I asked you whether what is written there is true.
The full instructions we received from Council for Ontario are appended at Appendix H. Is that statement true? Yes.
Thank you. You also had instructions for your nominal values report. You remember those instructions generally?
I think so.
Do I have to go
I don't think
through
so.
it, or can we, will you agree that the instructions are the same in both reports?
Yes,
Thank you. So can you go to Appendix B at page 64 of your present value report, please?
yes.
And Appendix B starts off with the following statement. 1, this appendix describes how band trust accounts, BTAs, and Robinson annuities have operated based on instructions from Council for Ontario. I'm going to stop, pause there. Now, I looked in those instruction letters you got, and there's no instructions about the band trust accounts or the history of interest calculations. I'm suggesting to you, you must be referring to some other instructions you received.
I think that's true. And I'd like to expand if you allow me.
Well, maybe we could answer, sort of, let me ask the questions, and if you don't think that my questions are fair, you can tell the judge. And tell me too, and I'll try and be responsive. Did you receive other instructions from Ontario?
We had many communications back and forth with Ontario over the course of 2.5 years, leading up to the submission of our reports. I would go so far as to say that in saying our complete instructions were appended at Appendix H, we're referring to the instructions which led to the preparation of the reports, and the reference to instructions here probably should be interpreted as referring to the broader discussions we had about what documents we should rely on in responding to the formal instructions. And if that's splitting hairs, I apologize. I'd be willing to acknowledge that there appears to be an inconsistency between, and I accept your statement that there's no reference to the Angel report at Appendix H. Therefore, I would accept there's an inconsistency between the statement in paragraph 6 of the present value report that you cited and the statement in paragraph 1 of Appendix B, or wherever it is in Appendix B. I agree that's an inconsistent reference to the instructions we received from counsel. I hope that you and the court understand that, of course, we're guided by broader discussions, and in particular, when it comes to the questions of what evidence we economic experts should take as given, or where we should rely only on our own research and expertise. In this case, which is so complicated and involves so many experts, we were in need of guidance on that point. So that's what we're talking about now, that those instructions refer to this broader guidance on what we should take from other experts and what we should not.
All right, so you know, it's important in assessing what weight to put on your report, what your instructions are, and how that may have been affected, how those instructions might affect your task. So I think it's important to know what those instructions are, and are they in writing at all?
Our instructions formally were written down and given to us in a letter, which is appended at Appendix 8. We did have other communications, written and oral, which I can talk about in general terms. As I understand it, I'm not supposed to talk about in specific terms. I will do my best.
I don't want you to tell me about conversations you had with the lawyers at Ontario generally. I'm looking specifically for instructions they gave you, and
Yes.
I gather, I'm reading between the lines here, but I gather when it came to your reports, they instructed you to look at the Eric Angel report. Is that true?
I would say that they authorized us to read it. They provided us with a copy and they authorized us to make reference to it in our report. I think your broader, if I may, I think your broader question is, were we instructed to draw any conclusions or to make any statements in our reports by Ontario? And other than the trivial ones, such as you must include your CV, you must include your instructions letter as appendices and so on. We received no such instructions to tell us what to do. We are economists. Professor Bodway has more experience than me in testifying before Superior Court. I have none. Of course, we needed broader guidance. Here, we use the word instruction, but I would make the distinction. We needed broader guidance on what we could rely on and what we could not. Indeed, I think even a more experienced expert witness than myself would need guidance in this case on that because of the incredible complexity and the large number of experts involved. And indeed, the ambiguity about those questions of when one expert can rely on the testimony of another. I don't know the common practices, and I did rely on Counsel for Ontario to explain their understanding of those issues to me. That's what's referenced in the first sentence of Appendix B.
That's not what the first sentence of Appendix B says. It says quite clearly that you were told to assume a number, to make a number of assumptions in your report. Uses the word assumptions. Do you see it there? Paragraph 1?
I do see it, and I could clarify.
Well, I think the court would like you to clarify. I would like you to clarify.
Appendix B is about the history of interest calculations on annuity counts. It's clearly closely related to our work on present value, the interest rates that we use to bring forward numbers to 2020, and related to the differences between our approach and that of Mr. Hutchings and Professor Stiglitz. In preparing our reports to deal with those present value questions, we did our own research into the functioning of band trust accounts. We were also informed by Counsel for Ontario that Dr. Angel had been engaged to work on the same questions. We were additionally asked to consult from time to time with Dr. Angel so that we could share our different expertise on different aspects of the related issues. So we had full awareness of that, thanks to guidance from Counsel for Ontario. When it came time to write our report, I will tell you that my belief of what Ontario Council were trying to do here was to ensure that the witnesses, the expert witnesses, didn't step on each other. And so in particular here, we were told to rely on certain statements that Dr. Angel had made instead of asserting our own authority to comment on those matters.
Is there a letter to that effect?
There is not. There
Just
is
happened
no
earlier.
letter to that effect.
Is there
that
an
I'm
email
aware
to
of.
that effect? Is there any documented communication of that instruction, direction, guidance, whatever you want to call it?
Not that I'm aware of.
Were you instructed to consult with other experts other than Dr. Angel?
Yes,
Who?
Professor von Gurnet and expert witnesses engaged by counsel for the plaintiffs.
And can you name the expert witnesses engaged by the plaintiffs?
I'm going to amend my previous answer. Dr. Hamill as well was engaged by Ontario. We engaged with him as well at the direction of counsel. But your subsequent question was, could I name those other experts? Is that right?
Yes.
We met repeatedly with Professor Carl Beal and Mr. Hutchings, occasionally with Mr. Hamill. Professor Stiglitz was invited to those repeated meetings, but did not attend any of them. Those meetings went on from January 2020 until sometime in late 2021, as I recall.
Is that it?
I think so.
Thank you. Did, in your discussions with Mr. Angel, did he provide you any assistance in writing about his subject area that he was responsible for?
I think you may have just corrected me. I think that Eric Angel has a PhD, and I referred to him as Dr. Angel. Am I mistaken?
Does it matter for the answer? I mean, have I offended someone by asking the question that way?
Yeah, people in my line of work care a lot about these distinctions, to be honest. I'll continue to refer him to as Dr. Angel. If you tell me I'm wrong, I'll stand corrected. So your question was.
We can call him doctor. We can call him a lot of things. You know, professor, doctor. I don't know if he's a professor. Right. Let's call him doctor. Okay. So Dr. Angel, did he provide you with help in writing?
No, I don't have any awareness that he ever read our report, and certainly he did not offer comments on our report.
You read his report, though, I take it,
Yes,
and you took his report into consideration in preparing your reports. Is that fair?
yes,
And you read Dr. Von Gernitz's reports, did you?
portion of Professor Von Gernitz's report I read.
And did he provide you with written guidance on anything?
No, I only attended a small number of meetings with Professor Von Gernit relatively early in our work that began in 2020. And I cannot recall the specific issues that arose in those meetings at the moment. Certainly, I never received any communication from him in any written or electronic written form.
You read his reports, that he has 2 reports before the court. Are you aware of that?
I'm not aware of that.
So you read one of them.
I read a portion of one report, which I received from Council for Ontario roughly in March 2023.
March 20,
23, that's this year.
so are you suggesting, sir, that you did not read Dr. Von Gernitz's drafts of I'm calling it a draft, any draft of his report? Or or am I to understand you reviewed a draft of his report before you prepared your report?
I cannot recall that I did read a draft of any report by Professor Von Gernit before this year. Of course, I'm a co-author of our reports. I cannot speak for Professor Bodway's reading and the way he prepared for his component of our reports. He will be here next week, as I understand. And indeed, I may misrecollect what I read in, say, 2022. I'm telling you, my complete recollection today does not include reading a Von Gernit report before this year, and even this year, only a portion of one. But I've read a lot of reports. in preparing for this case. I must say that I'm not completely certain that I didn't read any such report, but I don't think so. And I don't recall any place in our reports that would indicate otherwise. But I'd have to review, if I were to take more time and review my own reports with Professor Bodway, maybe it would jog a memory. I don't think so.
All right. But you did have conversations with Dr. Von Gernert prior to preparing your report.
Yes,
You did not consider the reports of Dr. Driven, did you?
I did receive the Driven report in 2022 and read it. Yes,
And so you had it before you prepared your report?
yes,
And you say you considered that report before you arrived at your opinions and conclusions?
yes.
Care to explain how you factored in any of his comments? Like Bemadzewin, let's talk about Bemadzewin.
I'm having trouble hearing that word.
There's a concept that he wrote about called Bemadzewin. He also wrote about reciprocity. Do you remember reading about that?
I don't. This was over a year ago. And I don't recall.
All right. Did you consider the report of Dr. Bignami?
I did read a portion of that report. Yes,
And was that done prior to finalizing your report?
yes,
Now, the court knows, and maybe you know as well, that there were a number of lay witnesses that testified earlier on in this trial process. Are you aware of that there were lay witnesses?
no,
So you haven't, before
Oh.
taking the stand, you haven't considered what they had to say, how it may in any way affect your opinion?
no.
Now, earlier on, we're changing subjects here. Earlier on today, we had talked about the changes from your June version of your report, June 2022 version, to the version that is now before the court. And it's my understanding that the only changes were made were redactions of RHT specific data. Would you agree with that?
The only changes were made to what?
To the reports exhibits 61 and 62 and 60, 61, 62, 63, and 64, I guess. All of your reports, the redactions made that removed reference to RHT. Those were the changes that were made.
I'm not sure what council does in terms of documents. As you know, because you asked me about it before, we prepared a full set of revised tables reflecting all of the changes, and those are in your hands now. Or perhaps not literally, I'm not sure what's in your hands, but you have possession of a completely updated set of tables reflecting all of the changes.
Yeah, that wasn't my question. My question was what was changed in exhibits 60 through 64. And I'm putting to you that what was changed, and I'm okay if council helps me on this. It's not a difficult question.
Sorry, would you like me to provide a little more information?
Yeah, if you can confirm, I'm okay with, I'm just trying to have the witness confirm that what was changed was the deletion of RST specific data. RHT,
Um,
specific data, thank you.
So obviously, I'm not the witness. I'm providing information to the court counsel. The changes between the original version of Professor Smart and Bodway's report, so that would be from June 30th, 2022, to the current version before the court. There were a few changes. So there was redaction of references to Dr. Carl Deal, who was a expert witness that the school plaintiffs originally had put forward, who was unable to testify, and so his reports were removed. And references to him were removed.
Can we call that deletions? Of
Yes,
references?
They were redactions, yes, of references to Dr. Beal.
Thank you.
The second item was there were a few adjustments made to reflect the RST area agreement among the parties. Are a few minor changes, as I recall. And then the third category is the category that my friend Mr. Schachter is speaking to, which is redactions to remove references to the RHT, certain references to the RHT. That's the information I'd like to provide.
Thank you, counsel. Would you adopt that, Professor Smart? What the lawyer for Ontario just said?
I just can't speak to the communications among the lawyers. I prepared various versions of my calculations at various times. And I'm fully able to speak to my calculations and my estimates and the process that led to my calculations at every step of the way.
Mr. Schachter may or may not pursue this, but I am finding it very difficult to understand whether you are saying you have no idea whether what Mr. Lipton said is correct.
Well, Your Honor,
Sorry, and that's because you have answered a question that said you reviewed the changes,
yes.
you and Professor Bodway.
Yes. Yes, and I prepared the tables that are in every report.
That's
that-
not the question.
Well, I'm doing my best to answer
Okay, well,
the
I'm gonna
questions
ask,
posed and also I think the broader underlying questions, but
you are going to make assumptions perhaps about the broader underlying questions that you may be tripping yourself up. My understanding of the question is, you prepared a report.
Mhm.
The report now has some redactions. Mr. Lipton says the redactions are of
Mhm.
three types. You said you reviewed the redactions. You reviewed the reports with
yes,
redactions. Now you say, don't ask me what the lawyers do.
well,
I'm saying, is it possible you cannot accept
I can be fully explicit.
from having read
On
them,
what-
what Mr. Lipton says?
I would like to try to be fully explicit in response to Your Honor on what I
Okay.
know and what I don't know.
Okay,
It is true that the detailed review of the redactions was Professor Bodway's job, and he will be here next week. It's also true that all of the tables in all of our reports submitted to the court at every point were prepared by me. So what I can tell you is that I was asked at various times to prepare a new set of work papers and a new set of tables. In one case, I was asked to prepare a set of tables for the present value report that reflected the change in the boundaries. And I did provide those to council. I believe that those are probably what's in the version of the reports that were then redacted that Mr. Schachter has. But I'm not entirely sure that's true. It's possible the redactions might have been applied to the set of tables that existed prior to that updated boundary. I don't know, but I do know, I'm absolutely certain because Mr. Schachter showed us that he's not looking at the version of our tables, a redacted version of our tables that reflects all of the changes that we've made to our calculations.
that's where you're getting ahead of yourself. Just focus on, if you don't mind, the question.
Well, I believe I've answered it, and I could repeat the answer more briefly if you like.
Briefer is always better.
So I was asked to prepare a version reflecting the updated boundary, and that was provided to council. And it may be that that version is in Mr. Schachter's hands when he asks questions. And if he says is this exactly the same as what was prepared in June 2022? Then the answer would be no. But I just
The answer would be,
would be no. It would not be the same because it would reflect an updated boundary assumption.
okay,
That being said, because I cannot look at the two documents sitting in this chair side by side, I don't know the answer. And the question could be, I think, fully answered by Counsel for Ontario. I can answer questions about what I prepared at every step of the way. I just don't know what happened after I sent it on to Counsel for Ontario.
thank you.
All right, perhaps, and what I'm going to sort of telegraph to you, the witness, where I'm going with this. What I'm trying to demonstrate is that there are some artifacts of your earlier report that are now inaccurate, but remain in your report. So I'm going to go to those, okay? So let's take a look at page 12 of your present day report. Can you just pull that up? That's exhibit 61. Page 12, paragraph 27. Can I read you from paragraph 27? Do you want me to wait till you finish reading paragraph 27?
Please go ahead.
In the middle of the page, middle of the paragraph 27, as it reads, as discussed in more detail in the Bodway and Smart nominal values report, the Crown has incurred losses on NCRRs from the treaty territories since the 1980s. I'm going to stop there. Now, that might be the case for the two treaty territories, RHT and RST. Would you agree with that?
I would like to get instructions from the court whether I can answer Mr. Schachter's questions, making reference to data that are redacted or not.
If Mr. Lipton is going to object, he'll do that. Otherwise, question is fair game.
Please repeat it. I think the answer will be yes, but I think we're better off if you repeat it.
The statement at paragraph 27 is your opinion after considering the NCRR figures you use for both RHT and RST.
I think so, yes.
The answer is different if you only consider RST, correct?
Yes,
And if you're only considering RST, you would not opine that based on your data, there has been negative losses on NCRRs since the 1980s. You would opine it is since the 1960s. Is
Yes.
that fair?
yes,
Thank you. So this is an example of how there's, is it okay if I call it an artifact of your report that originally dealt with RHT and RST?
yes,
So throughout your report, sir, there are artifacts that include in conclusions based on your analysis of RHT and RST and not RST alone. True?
that seems to be true.
I want you to look at table C.2 of the same document, exhibit 61. I believe it's C.2 I'm looking for and just try and find it. Page 1. Oh, do I have the wrong report? It's the nominal values report then. It's going to be exhibit 60. I apologize. I must have the wrong report. We can either look at it at page 181 of exhibit 60, or I've also reproduced it, I believe, in the compendium somewhere at which tab number? Page 33, compendium tab number 11. I'll wait till you get there.
I'm there.
Mr. Lipton is on his feet.
Sorry, I would just point out just a technical point here. Compendium page 33 does not appear to contain the entire table C1 from the nominal values report. It appears to contain only the last page of table C1 as opposed to the entirety of table C1.
So we don't want any of C1 to be reported because that's the Huron.
No, I understand. It's just the way you presented it. Of course, you were saying you're showing all of C1 and you're in fact only showing a portion, just a technical point, but that's all I want.
Well, if I referred to C1, I don't believe I did. I believe I referred to C2.
Sorry, my mistake.
So we're looking at table C2. Now table C2 is your best estimate of net Crown resource-based revenues by category in the RST area. Correct?
No,
What is it?
well, several changes have been made and they are not reflected in this table. I was never asked to prepare table C2 again to reflect the changes that I described.
That's my only point. My point is, in June 2022, your report includes in a table C2 that at the time presented your opinion about the estimated net Crown resource-based revenues by category in RST. That's correct.
Yes,
Thank you. And there is no new table C.2 with new updated data, correct?
I think it may be in my work papers. I'm almost certain that it is. Did my opinion change? Yes, it did. It changed based on information provided from other parties and based on my own opinion of the best way to make these estimations. Mr. Hutchings changed his opinion as well. He didn't update everything either. And I didn't think there was any expectation that we'd have to go through all of that again.
So the table isn't updated.
In
Agree
this
with that?
document, no,
Thank you.
absolutely not. Indeed, I want to be explicit about that, consistent with what you said before. This does not, nothing in these exhibits. These exhibits do not fully reflect my opinion on the estimates of NCRs. The important bottom line conclusions that I now hold on those questions are reflected in my demonstratives, including the updated versions of all of the present value tables that were appended in that. I refer to pages 151 through 160, I believe, of the demonstratives, fully updated.
Can you turn, sir, to page 24 of your sir reply to Mr. Hutchings at paragraph 36?
Is this in the compendium? Because it would be easier for me.
Yes, take a look at compendium tab 7. Over on page 24 of the compendium, paragraph 36 has the following opinion. Excluding starting the third last line, first sentence, starting with 79.8 million. Your opinion is, excluding these expenses, would our calculated cause NCRRs for the two territories combined to rise by, then something's redacted, or 5.1% of the total reported in Bodway and Smart's present value report? See that's an opinion you held. It's not quite all that well grammatically stated, but the gist of what I'm trying to communicate, that I think you're trying to communicate to the court, is that it's only a 5.1% difference. It's not that much.
It's a little bit hard to parse these statements in view of the redactions, but I think what you said corresponds to what I think is said here.
What I said, you agree with me?
I think I do, yeah.
All right. But as it relates to RST, the picture is not a minimal 5.1%. As the chart below, table 3 demonstrates, it's 132.2%. You see that?
Well, we have to be very cautious here. First of all, the percent change, I think it's informative. I think it's worthwhile thinking about how big is a percent change induced by any particular assumption, but it's not the bottom line. Dollars are the bottom line.
I'm just going to remind you, instead of assuming what it means, just answer the question first, if you don't mind, because I'm focused on the question.
What was the question, Mr. Schechter? I'm sorry, Your Honor.
As it relates to RST, the picture is not a minimal 5.1%. As the chart below, table 3 demonstrates, it's 132.2%. Do you see that?
No, I do not.
Okay, I will try and help. We've now highlighted for you the digits 132.2%. Do you see that now?
I see that number.
Okay, so first question is now answered. Now, in respect of that 132.2%, that is not a 5.1% change. It's 132.2% change. Would you agree with that?
No, I would not.
Okay. Why is that not a 132.2%? Oh, maybe it's because I used change instead of difference, eh? Would you agree with me that the 132.2% is a difference as a percentage of the total for RST? Perhaps we can highlight the words difference as a percentage of total. We've now highlighted that on the slide or on the computer for you.
I'd like to answer this as it depends on how you calculate a percent. If we calculate the $79 million difference as a percentage of the final calculation of 60 million, then I think it is 132%. If we calculate the 79 million as a percentage of the original minus 19 million, then it is not.
So which one's right?
There is no right answer. And I was trying to explain before that we have to be cautious in using percent change, particularly when either the pre-change or the post-change number is very close to zero. That makes percentages very large. If we divide by anything by a number close to zero, the resulting percentage change becomes a very large number. And so in cases where we're talking about changes of something that's close to zero, we have to be cautious about how we do it. And we need to focus on the dollar change as well as the percent change.
All right, can we at least do this then? Can we, would it be wise to advise the court that when she sees your percentage numbers in your reports, she should pause before accepting them as accurate?
I'd recommend to anyone that they be very cautious in thinking about percentage changes. That's not the bottom line here. The dollars are the bottom line. And the bottom line in the case of this SIR reply report was $60 million after the change and $19 million negative, $19 million before the change.
I'll just let you know, Mr. Schachter is asking a number of questions about, or a number of questions about what's in the report and how one should read it. I'll just remind you that at the end of the day, I'll remind everyone here, at the end of the day, I'm in a room all by myself. And I'm going to be reading reports and looking at evidence. All by myself. There's nothing on this chart that tells me that that's not an important number. So it's actually not helpful for me to give what I think is an answer from you that is trying to assume that Mr. Schachter is trying to do something. I'm really listening hard for you to help me read these things.
Yeah.
Okay. That's all I can say.
I would like to help the court as much as I can, even on this one specific question of the impact of the change in the treatment of this recreation and resource management program that we affected back in December last year. Your Honor just referred to your need to understand what's an important change and what's not. Mr. Schachter hasn't asked me whether I consider this an important change, and you told me not to answer questions he doesn't ask.
No, I didn't ask you what's an important change. But I just said, if I have to read this report and I read a line that I believe you wrote, difference as percentage of total. And there's a question asked about that. And you say, depends how you calculate percentage.
Yes.
But you're the one who calculated percentage. So maybe an answer could be, this line means this when I did this.
I did provide that answer, Your Honor. I said that 79 million divided by 60 million is 132%. And I wish to say again, if I may, my goal is to inform the court of what I consider important here. And I will do my best to provide that kind of guidance at every step of the way, including if I were asked whether I consider this change to be important or not, I will answer that question.
Perhaps we can turn to your demonstratives, slide 69 of 161. I'll wait till you get there and you can tell me when you get there and then I'll ask a question.
You want me to refer to my own demonstrative deck?
Yes. So we also have slide 69 up on the computer. I want to ask a question about the final bullet. I'm going to read it to you. Mr. Hutchings is objecting to the amount of expenses we record, not the principles we used to arrive at those amounts. There isn't a period, but that's what I would put a period after the word amounts. You see that there?
Yes.
Is your intention in writing that to communicate to the court that in all instances of disagreement with Mr. Hutchings, he does not object to your principles, but only to the amounts of the expenses we record?
No, I didn't mean to suggest that kind of generality here. Rather, what I was suggesting here is on this issue that Mr. Hutchings raised in his reply report and in his testimony, when he talks about what I call the rising cost of government after 1945, he presents our data. And in my reading, in my opinion, what he's saying is, gee, those expenses are high. It's not a principled objection to the methods by which we computed those expenses, estimated those expenses. Instead, it is what I wrote here, an objection to the magnitude of them.
Would you agree with me, sir, that Mr. Hutchings and Professor Stiglitz have a difference with you that extends to a difference in methodology of calculating NCRRs?
Yes, in general, and specifically here as well. Mr. Hutchings' method did not include the PAO data after 1945. That's a key methodological difference between us.
Another methodological difference is that you look at those expenses that support rents, and Mr. Hutchings and Professor Stiglitz look at expenses that support relevant revenues. That's a difference as well.
If I understood what you just said, I don't think it's accurate. It may be, could I offer my guess about what you meant, or just to
No,
make things go faster?
no, I
Sorry.
don't want you to guess about what I think.
Sorry.
Your methodology looks at those expenses that support rents.
I don't agree.
Okay.
Oh, I do agree. I understand what you mean by supports rents. Yes.
Mr. Hutchings' NCRR methodology does not look at expenses that supports rents. He looks at expenses that support relevant revenue.
I understand now the distinction you're making, and I have to withdraw my previous agreement with your statement. We include expenses which support revenues as specified by the decision of the Court of Appeal. And the way we frame that question is by first starting by determining what are resource rents, and then determining what portion of those resource rents accrue to the Crown as NCRs. So when you made the statement, you include expenses that support rents. In fact, in our mind, what we're doing is including rents, expenses that support NCRs by first determining whether they support resource activities and therefore resource rents, and then determining the extent to which they're accruing to the Crown as revenues.
So your first question is, does the expense support rents?
Yes. First question, first step of the way.
A second example where your methodology differs from Mr. Hutchings is that you charge to the RST portions of expenses incurred by the Crown wholly outside of the treaty territory, and he does not. Is that true?
I wonder if you could give me an example.
You don't know of any examples that come to mind?
Of his methods or of my,
Of
Professor
you
Barclay.
including in expenses that were incurred outside of the RST area, you include in your analysis a portion of those as a function of your calculation.
I find it difficult to give a yes or no answer to a question as open-ended as that. If I could clarify, what we do is take the public accounts of Ontario as our starting point and the expense component of in particular, which is relevant here. And those record data for the province of Ontario as a whole. So in general, when we start our estimates, we start the process of performing our estimates, we start with data that includes expenses in territories outside the RST. That is true. Does that answer your question?
No. Because when you allocate the expenses province-wide, you allocate it as a percentage of province-wide expenses. Correct?
The specific statement you just made is not correct. I'm sorry.
When you allocate the expenses province-wide, you allocate it as a percentage of province-wide revenues. Is that correct?
That statement is correct.
So did you know that I made a mistake by referring to expenses and just wanted to leave me hanging, or what? Or did you not realize I made a mistake?
I did realize that either you made a mistake or you're asking me a question which was tautological. And in either case, I gave the best brief answer that I could to the specific question I was posed. And if that's not my job here, someone should tell me.
Well, it's not for me to tell you what your job is. Mr. Hutchings has a preliminary step before he determines what expenses to allocate. He asks the question, which you do not in your methodology. Did this expense happen inside or outside of the treaty territory? You know that he makes that distinction. He asks that question, excuse me. You know that.
I know that he raised that issue in his reply report. Yes.
You do not do that. You don't first ask a geographic question, do you?
Again, our process is to start from the province-wide public accounts of Ontario, determine whether expenses should be included or not, based on whether such expenses support the kind of resources that exist in the RST territory or did exist in the past. And only then, having included province-wide expenses, do we apportion those province-wide amounts to the territory in ways similar to Mr. Hutchings. That being said, the question you asked me was, do you agree that Mr. Hutchings has another step prior to that and that you do not? And on both points, I don't fully agree. I'm not aware that Mr. Hutchings ever described a specific step in his own process or his own methodology that involved first identifying whether expenses occurred inside the territory. Rather, this issue of dispute of how to do it came up in our reply and reply reports. It's also not true that Professor Baudouin and I never do that. There are certain cases in which we saw province-wide expenses in the public accounts, and based on the geographic designation, we did not include them. So we had no absolute rule that said we would never do that. And I will give you one example. There is one case in, I would guess, the 1920s, in which the Department of Lands and Forests recorded a province-wide. Are you with me, Mr. Schechter?
I'm listening.
I'll give you one example. There is at least one case in the public accounts, I would guess in the 1920s, for which the Department of Lands and Forests, which is generally the source of expenses we include at that time, recorded an expense for the rat portage office. Now, we don't know what the rat portage office was involved in, but we know that that's the town now called Kenora, which exists outside the RST area. And we elected to exclude it. So if I refer you back to your question, compare it to this example, you asked, it's true that I'm trying to paraphrase you. You said, it's true that you never exclude expense on geographic considerations at a first prior stage before including amounts from the PAO. The answer to that is no, as the example should make clear to you. On the other hand, is it true that Mr. Hutchings always did that? No, I don't think that's necessarily true. He didn't state in his report that he always starts by doing that.
Okay, it's clear to me I have to be very specific with you, and I'll try to do so. The only single time you exclude out on a geographic area instead of looking at province-wide first is in respect of rat portage and Mississauga fire. Is that true?
That's not true. As I just said, Mr. Schechter, that was an example.
Give me another example other than rat portage and Mississauga fire.
I could not do so without reference to my work papers, which are not available to me sitting here. But I believe there are other examples in which we also did that. However, I will agree with you. I want to make this easy on both of us. I will agree with you that we did not adopt it as a general principle. We believed that apportionment for geographic purposes happens at the second stage, that we would measure a province-wide amount of a relevant expense. And then at the second stage, we would estimate the portion of it which occurred within RST. And we felt that if we had generally adopted the principle of first excluding anything that was geographically designated within the province-wide accounts of the PAO, and then at the second stage, again, apportioning to RST, we would commit the error of double non-counting of expenses. Let me explain what I mean by double non-counting.
I think you gave us that before, and I believe this line of questioning was pointing out differences in method. One method to ask geographic questions early, and your method not to. So that's where we are.
Then I don't need to explain if Your Honor doesn't wish it. I haven't testified on the point that I just spoke about. You may be recalling it from my reply report co-authored with Professor Baudouin.
Oh, sorry. So there's a theme here, and it's about method. So it would help me if you would do your best to stick to that.
I was speaking about method, Your Honor.
Okay, let's continue on with differences in methodology. It is indeed a theme. Mr. Hutchings requires that an expense to be considered for inclusion must be one whose expenditure has a reasonable prospect of supporting, regulating, or collecting a relevant resource revenue. And I'm going to call that a matching exercise. That's my words. You don't require that of your methodology. Is that true?
I'm not sure. The first statement, was it a statement by Mr. Hutchings or yourself?
I'm paraphrasing Mr. Hutchings' approach. His methodology requires that an expense to be included, considered for inclusion, must be one whose expenditure has a reasonable prospect of supporting, regulating, or collecting a relevant resource revenue. You don't take that approach, and he does. That's a difference.
Well, it depends on what you mean by supporting a revenue. It does. If you wish me to comment on the specifics of what Mr. Hutchings did or what Mr. Hutchings said he did, I would ask you please to give me the opportunity to read in one form or another his statements, and I will tell you whether I agree with them or not.
Well, you're not able to answer that question without looking at his report.
I will repeat my answer to the question that you posed me, which I think is referable to your own sense of how this should be done. And the answer is, it depends on what you think of as the meaning of the phrase supporting revenues.
Okay. I'm trying to focus in on his approach that expense has to have a reasonable prospect of supporting them. Right? Whether it's supporting rents or supporting resource revenues. The point is, you take issue with his approach of requiring there be a reasonable prospect that there will be a positive gain. That's what you take issue with, right?
I disagree with your characterization of what his method is and whether I disagree with the statement that you just made. I don't disagree with the statement you just made. I just disagree that it's a characterization of what Mr. Hutchings said that he was doing or what Mr. Hutchings did. If you want to ask me about that, I would suggest that we both refer to things that Mr. Hutchings said, and rather than the things that you are now saying, Mr. Schachter.
Perhaps would be a good time for a break right now.
I think so. Timing? It's 12:40.
I'm in the court's hands.
How you doing?
I'm not making great progress in time.
2:50. 1:42. Is 2 o'clock too early? 2 o'clock?
Yeah, that'll be fine.
All right, let's take that break.
All rise. This court recess until 2 o'clock.